Good afternoon, everyone.
Good afternoon.
Good afternoon.
Good afternoon.
Katrina, yeah, I had my mute on for a minute.
Judge she is logged on. Okay.
Good afternoon.
Good afternoon.
Good afternoon, Judge. How are you today?
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
It looks like we got a couple private attorneys on this calendar, Judge. I'm just letting you be aware of.
Okay.
Good afternoon, Judge. How are you?
Good afternoon.
Miss Holly's gonna be your litigation manager today. I'm just zooming.
All right, I'll go ahead and do my opening and then we'll get started. All right, good afternoon, ladies and gentlemen. My name is Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar for Wednesday, September the 7th, 2022. This is a calendar for cases in which individuals have been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and these cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address matters including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I'm going to also give you a state all-purpose reset date. And what is that
It will
date?
be September 20th.
September 20th.
Yes, ma'am.
All right. And that will be September 20th. I'm going to also begin by advising everyone that this whole entire proceeding is being live streamed and recorded on YouTube. I'm going to also let you know, the defendants on this calendar, that you have certain constitutional rights. The first one being that you have a right to an attorney at this proceeding, which most of you already have and know, whether you have the PD's office or a private attorney. You also have a right to remain silent. Anything that you say about the facts, the circumstances, and the occurrence of your case can and will be held against you. Please govern yourselves accordingly and listen to your attorney. The solicitors are here and are taking note to everything that you say about the facts of your case. This is not a trial, this is a bond hearing. So who are we going to start with first, deputies?
Michael Benson.
Good afternoon, Judge. If we can have a breakout for the Spanish interpreter, position 6 in courtroom 3.
Okay,
Yes. And also, Judge, this is going to be, whenever you're ready, this is position 7, Mr. Hudson. He has a private attorney.
all right, I think I see that.
And that's my case.
Chat.
Yes, and is the interpreter currently available? Because I would need that for my case, number 6.
Right, we have it for number 6.
Yes, ma'am.
But you're asking for a breakout on number 5.
Right, just to discuss the issues on the case on number 5. Number 6, I still need to interview Mr. Enriquez when the interpreter is available.
Okay,
I don't think she's on the line yet.
yeah, I don't think
Okay,
she may be getting on soon. Sometimes she's going from courtroom to courtroom.
understood.
All right, as soon as she gets on, I see we also need a breakout for position 13?
Yes, Your Honor, for the allegation only.
All right. So we going to the breakout first, or we going to hear a case first?
Right now, we're gonna be starting in courtroom 2, Judge, with position 7, Mr. Hudson. He has a private attorney.
All right, we start with position 7. All right, this is 22 CR 006016F, Martell Hudson. You're charged with 1 count of battery. The offense date is March the 5th, 2022. And the private attorney is Mr. Dixon. Is that correct?
Yes, Your Honor.
Okay. Did I pronounce it right? Bixon Bixon?
You got it.
Okay, good. All right, go ahead, pretrial.
Counting about 9 adult arrests.
Yeah.
2013 out of Chicago, domestic violence. This says direct file with the court. What else? 2012 possession of a controlled substance, possession of ecstasy. 2019 FTA for suspended license. 2017 suspended license. 2014 fugitive from justice. That's it. He got a history out of Wisconsin too.
All right,
This is real old.
okay.
Yeah, it's like 2004.
All right, and Miss ASG Reed?
Thank you, Your Honor. Excuse me. The date of the offense was March 5th, 2022 at 460 North Avenue Northeast. That's a Pizza Hut restaurant. Miss Armstrong, the victim in the case, her name is Tina. It's spelled Teanna, Armstrong, common spelling. She used to live with the defendant along with her boyfriend and her 3 children. Miss Armstrong was the former manager of the Pizza Hut, and she was transferred to a new location. Now, the defendant is the current manager of the Pizza Hut where the incident occurred. On March 5th, Miss Armstrong went to the Pizza Hut where the defendant was the manager to pick up her last paycheck and turn in her key. The defendant was called to the location, and a verbal disagreement between the defendant and Miss Armstrong turned violent. Miss Armstrong told the officer that the defendant opened her car door and struck her in the face with a closed fist. The officer observed a minor scratch on the left side of Miss Armstrong's face. The defendant left the scene before the officers arrived and a warrant was issued. Our office has not been able to make contact with Miss Armstrong, so we are asking for no further contact, just in abundance of caution. The state has concerns that the defendant does not have strong ties to the community since he does have a criminal history out of the state of Wisconsin and the state of Illinois. The state recognizes that there has been a sufficient cooling down period between the parties, and for that reason, Your Honor, we're only asking for a $2,000 surety bond. Other conditions would be no further contact with Miss Armstrong, a 1-day anger awareness course, and no drugs, alcohol, or weapons. Thanks.
All right.
Judge, this is Mr. Martell. Is the court ready for me to begin?
I'm sorry, didn't hear you well.
I was just going to ask if the court's ready for me to begin. I started talking and I didn't even ask.
Yes, it's a little fuzzy for me. Let me
Gotcha.
see. If
I will
I
get closer
can-
if that helps.
Well, I have my volume up. Are you back from the mic, or are you able to get any closer to yours, Mr. Bick?
Here, is that for Judge?
Yeah, that's a little better. Thank you.
Okay, wonderful.
All right, you may proceed.
Your Honor, this is Mr. Martell Hudson. He's 36 years old. He's lived in Atlanta for between 8 to 9 years. His boyfriend lives here in Atlanta with him. His cousins live here. As previously stated, he is still actually the store manager at Pizza Hut. He's worked there for 8 years full time. He's a high school graduate. Judge, I obviously haven't had an opportunity to fully review his criminal history. I heard what pretrial said earlier. I would like to go through and confirm some of those later on. Regarding the incident at hand, Judge, we vigorously deny the state's position on the case. It's pretty clear that, from talks that I've had with him, that this seems to be a case of retaliation against him for testifying against the state's victim in another case, and she has made declarations as such. Judge, considering his lack of history, the fact that he's been here 8 to 9 years, he's a manager at a store here, and the fact that his family is going to be fairly indigent, just due to the fact that he's been arrested and he's been in custody now for almost, I think, 5 days, I want to say. We would just ask for a signature bond on this case, Judge.
All right.
And Judge, just to let you know, a little bit going into the 5-day thing, he was actually arrested, I believe, on Thursday or Friday. City of Atlanta found out about the warrant at a stop, and then they held him in custody. I think he just got transferred last night or yesterday to Fulton County, but he's been in custody since then.
Right, at the city, not at the Fulton County jail.
Correct. Yeah, he got transferred to Fulton County yesterday, but he was being held on this warrant.
Okay. All right. I'm going to order that we issue a $2,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond, except for prescription drugs prescribed by a doctor. I'm going to order no further contact with the victim, Tiana Armstrong. And I guess that will be it, because I will not obviously order the stay away from his place of employment if he's still working there. But certainly no further contact with Miss Armstrong once he makes bond. And I will not order the class at this point.
Thank you, Judge.
All
Thank you,
right.
Judge.
All right, that will conclude this case. Thank you.
May I be excused, Judge?
Yes, you may. Thank you, Mr. Bixon.
Thank you.
All right, you're done.
All right.
Condition 11, Smith.
Okay.
Who is this?
This is 11, Christopher Smith, 22 CR 006011J. You're charged with 1 count of criminal trespass, family violence. The offense date is November the 16th, 2020. Pre-trial?
7 total. Last arrest was back in July out of Nashville. Theft of a firearm. It was dismissed. He was found guilty for evading arrest from March out of Nashville. He was arrested here in March, FTAs, possession of marijuana, possession of a firearm during the commission, and possession of cocaine. He was originally arrested for that in 2019. 2018, misdemeanor shoplifting. 2018, trespass, family violence, that was dismissed. He's out on pretrial for the possession of marijuana and the firearm. That's it.
Okay. All right, ASG Mitchell.
Yes, good afternoon, Your Honor.
Good afternoon.
In this case, on November 16 of 2020, the defendant got into a verbal dispute with his mother and victim in this case, Miss Erica Smith, common spelling, and got so upset that he ended up throwing several glasses that she had just received as birthday gifts onto the hallway floor, breaking them. The police report states that the mother doesn't want to press charges. Our victim advocate had an opportunity to speak with the victim, and she stated that she barely remembers the incident and forgot about it. This happened when they had just moved back to Atlanta, so no one lives at the incident location. The defendant and the victim do not reside together, but they do still have contact, and it hasn't been any violence since, so she still doesn't want to press charges. The state's bond recommendation in this case is going to be a $3,000 surety bond, no further violent contact with the victim, Ms. Smith, a 1-day anger awareness, and no alcohol, drugs, and weapons. Your Honor, as heard from pretrial, the defendant has the felony case in Tennessee and Georgia, theft of firearm that was in July of this year in Tennessee, and then possession of cocaine and possession of firearm in 2019 here in Georgia. He also has a prior criminal trespass, family violence arrest in 2018 in Clayton County. So this isn't his first. We do have concerns, the defendant being a flight risk, being that he was convicted of evading arrest in Tennessee this past April of this year. And he also has 3 failure to appears in Georgia in 2020. So with that being said, we are recommending the $3,000 surety bond in this case. Nothing further, Your Honor.
All right.
Good
McLeod,
afternoon, Your Honor.
good afternoon.
My client is 21 years old. He grew up in Georgia. He lived in Tennessee for a little while because he was working there. He has been back in Georgia for some time now. He has 11th grade education, he tells me. He had to drop out of school so he could help out with some family matters, Your Honor, and that is why he has not yet graduated from high school, but he hopes to finish his GED. The alleged incident, Your Honor, happened some time ago, more like 2 years ago. Even though my client has had several arrests, not all of them have been convictions. And just because he's been arrested doesn't mean that he's guilty. The prosecutor has stated that the alleged victim, his mother, says she barely remembers the event. She obviously is not interested in seeing my client criminally prosecuted over this. He does say it's a long time ago and he doesn't really remember the incident either, Your Honor. I think in this case, given what happened, the way the victim herself feels, and the time that has elapsed, that a signature bond would be appropriate for my client in this case, Your Honor. He has no intention of fleeing. His mother and his 2 siblings are here in Georgia, and he is originally from Georgia. Just because someone has lived out of state is not an indication that they are necessarily a flight risk. Thank you, Your Honor.
All right. I'm going to issue a $2,000 surety bond. I'm going to order no further violent contact with the victim, Erica Smith. I'm going to order no drugs, alcohol, or weapons while on bond.
I think she's on the Zoom, Your Honor. I did not realize that Mom was on Zoom.
Oh,
She is on the Zoom, Judge. I had stopped her video because she was not address appropriate for court. So I don't know if she is willing to speak at this point.
Is she dressed appropriately or can she?
I
turn
don't know. I
her
stopped her
camera?
video. I don't know. I can bring the video back on and see if she is, but I stopped it.
All right, let's see real quick. If not, I will go by the same rule. Ms. Smith? Ms. Smith?
I'm here.
All right. Have you changed or dressed differently from before? I can kind of barely see you. It's a little dark.
Well, hold on. I'm here.
Okay. All right. Do you wish to address the court regarding this case with your son?
No, ma'am, I'm fine.
Okay. All right. Well, appreciate your time and getting on the Zoom, but I have ordered a $2,000 surety bond and no further violent contact with you as the victim in this case, and no drugs, alcohol, or weapons while on bond, but there are no other conditions at this time regarding the bond for your son.
Yes, ma'am.
Okay. All right. Good luck to you. I'm sorry.
So I just go bond him out?
That will be up to you if you want to do that.
Okay.
Okay.
Yes, ma'am.
All right. Thank you. Good luck to you all.
Thank you, Your Honor.
All right. Thank you.
Position 10, Robinson. Have a seat over here.
All right. This is case number 22 CR 006015H. Nicholas Robinson, you're charged with 1 count of battery family violence. The offense date is June 16th, 2022. Pretrial.
First.
Okay. All right, ASG Reed.
Thank you, Your Honor. The date of the offense for this case was June 16th, 2022 at 961 Lena Street, Northwest Atlanta. And the victim of this case is the defendant's father, Gary Ray, common spelling. Currently, there is no bond set. The officer went to the incident location because of a dispute call. Mr. Ray told the officer that his sons, the defendant who was 20 years old, that's Nicholas Robinson, as well as Aaron Robinson, who's the other son who's 22, both attacked him with closed fists, causing a cut on his cheek. Mr. Ray declined to tell the officers what the fight was over, and our understanding that there is still an outstanding warrant for his brother, Aaron Robinson. But based on the police report, Mr. Ray does not live at the incident location, so the state will not be asking for a stay away as long as he does not reside there. Since our office has not been able to make contact with Mr. Ray, we are asking for a no further contact for safe measures. As Mr. Howard said, this is the defendant's first arrest, but the state still has concerns since this is a family matter and the victim was his own father. For that reason, we're only asking for a $2,000 surety bond, no further contact, a one-day anger awareness class, and no drugs, alcohol, or weapons. Thanks.
All right. Ms. McLeod?
Yes, Your Honor. My client is 20 years old. He works and has been working for the past 3 years, he tells me, as a cook in a restaurant. This incident happened with his dad. They had a disagreement because his dad came home and he was drunk, and generally his dad hit him with something, and he had a response, but then he subsequently left and cooled off and he went back home. He's been at home since, living with his mom and his dad. I was not able to speak with dad because dad was at work, but I did speak with mom, and she told me that everything is fine at home with all of them. I think she may be on the Zoom, I don't know, but I did get the opportunity to speak with her. And she said both her husband and her son were fine, and they resolved that issue the following day. Since this is my client's first arrest, Your Honor, I would ask the court to give him a signature bond with no further violent contact with his dad. I think that would be appropriate in this case. Thank you, Your Honor.
All right. Is there anyone on this call regarding Nicholas Robinson? Anyone regarding the case of Nicholas Robinson? I don't think the mother is on. It doesn't appear.
And Your Honor, with all due respect, Ms. Robinson is not the victim, so she just really is not the one to make that decision. Mr. Ray would be.
Right. And I'm sorry, is Gary Ray? There's no one. I don't think I see an iPhone. All right. Mr. Ray is not on. I will go ahead and make my ruling.
Yeah, mom said he was at work, Your Honor, and he could not get on the Zoom at work.
Okay.
That's what she told me when I spoke with her.
All right. Pretrial.
This is his first arrest, Your Honor.
Yes.
Okay. Will you take him?
Yes.
Okay. All right. I'm going to order a $2,000 surety, signature bond through pretrial. $2,000 signature bond through pretrial. I'm going to order the one-day anger awareness course. I'm going to order no further contact with Gary Ray. And I won't order a stay away from the address since it appears he does not reside there. But because he can have no further contact with his dad, obviously he won't be visiting while he's on bond in order to comply with these conditions. And there's no drugs, alcohol, or weapons while on bond. All right.
Thank you, Your Honor.
All right. That should
Thank you, Your
conclude
Honor.
this case, okay?
Position 1, Butler.
This is case number 22 CR 006012J. Sanford Butler, you're charged with 1 count of simple battery family violence. The offense date is September the 5th, 2022. Pretrial.
14 total. Last arrest was 2018, probation, DUI, reckless driving. 2018 FTA, it was not prosecuted for the DUI. 2014, another probation that was dismissed. 2012 probation, 2012 probation. From a DUI from 2012 out of Gwinnett. All he got in his history is DUIs and probation violations for DUIs. He don't have any violence.
Okay. All right, ASG LS Duncan.
Yes, Your Honor, as pretrial stated, this defendant has 14 cycles. He has 7 counts of DUI since conviction counts since 2001, as well as 2 probation revocations in 2012 for those DUIs, in addition to an FTA from 2018 arrest. This incident did occur on September 5th, 2022 at 822 Ashley Lane in Alpharetta. The defendant is accused of having slapped his wife's hand after a drunken domestic dispute. It's indicated by the warrant that both the defendant and the victim have issues with alcohol abuse, and they decided to, I guess, break their sobriety for Labor Day, and it resulted in this dispute. The victim in this case is Kimberly Butler, Kimberlee. Our victim advocate did get a chance to speak with Mrs. Butler in this case, and she stated that they live together and that they are married, but they have no children. However, she did tell us that she has been married to this defendant before, and that this is not the first time that he's been violent towards her. She said that this second time around, she thought that it would be different for them, but it has not been. She stated that she has a concern about how the defendant will react once he's released. She stated that she has filed for a TPO, and she states that she wants no contact, a stay away from the residence, and a one-time escort to retrieve his belongings. Given the facts and circumstances of this case, Your Honor, we have a concern about the risk of reoffense, given that the victim in this case stated that it has happened before. We have concerns about intimidation of the witness, because she did state to our victim advocate that she does have some fear towards the defendant. And we also have a concern about the flight risk, given that there is a recent FTA and the likelihood to respond to the legal process, because he does have prior probation violation. I just want to clear for the record that that slap after the domestic dispute did happen in front of a police officer. He was called for another disturbance between the two, and when he was telling the defendant to leave the location, the defendant got angry when the victim tried to help him facilitate the process, and he smacked her at that time. Given the facts and circumstances, we're going to be requesting a $3,000 surety based on his past history of violence with this victim and the number of probation violations and FTAs. We're going to ask for that no further contact in relation to the victim's request, a stay away from the home, one-day anger awareness, the one-time escort, no alcohol, drugs, and weapons, no further violations of Georgia law. And we also ask for an ADET, since it is indicated by the warrant documents that this incident did involve intoxication and the use of alcohol and drugs. And given his history with so many DUI convictions, we feel that this recommendation is appropriate. Nothing further from the state.
Okay. I'm sorry, Mr. Bartels.
Yes, Your Honor. That is my case. I have spoken with Mr. Butler. He is 44 years old. I'm advised that he works full time, that he is a project manager at North Georgia Concrete Company. I'm told that that is a full-time job. And I'm also told that he has relatives, including both of his parents and his brother, that live in the metro Atlanta area. So he is stably employed. He does have ties to the community. We would dispute that he is a flight risk. As pretrial indicated, he does not appear to have any violent history. There is a problem with alcohol, but there's nothing to indicate that he's a dangerous person or would be a risk to do anything to obstruct justice. I did speak with the alleged victim, Ms. Butler. She did indicate that they had both been drinking, and what she said to me regarding no further contact is the same as what the state has said she stated to them. So I have advised Mr. Butler that if the court does issue a no further contact order, that he would have to have some other place to stay. But we would ask that he be allowed to go back with law enforcement there and retrieve his belongings if there is a no further contact order. And given all that, Judge, especially with his lack of any violent history, we would ask the court to consider a signature bond. If that's not possible, since this is a simple battery, there's no injury alleged, we would ask the court to consider $1,000 good bond if it's not a UJR.
And I just wanted to state for the record that the victim did state that she might be on a Zoom if Your Honor would like to sound for her.
All right. Is anyone on regarding the Butler case, Kimberly Butler? Ms. Butler? Don't think I see her on. All right, I'll go ahead and give my ruling. I will order a $3,000 signature bond through pretrial. I'm going to order stay away from the 822 Ashley Lane in Alpharetta. I'm going to order no further contact with the victim, Kimberly Butler, at this time. I'm going to order a one-time law enforcement escort. Mr. Butler, you're not to return to that location unless you have a police escort to retrieve your personal items. I'm going to order the one-day anger awareness course through pretrial. I'm hesitant on the ADET because it's usually not done at this stage, but I do have some concerns regarding your alcoholism. I don't know if you're in AA or not. You are?
Yes, ma'am, I am.
Okay, so then I'll make that a condition of the bond is that you continue to go to your AA meetings and comply with your sobriety journey. Okay?
Judge, I'm sorry, what's the bond amount?
$3,000 signature bond through pretrial.
Thank you.
All right, that's it for this matter.
Thank you, Your Honor.
All right.
The judge, the Spanish interpreter is on the line. I don't know if you want me to take her and Mr. Bartell to courtroom 3. Mr. Bartell has the first part of the calendar, so I don't know if the courtroom can address the second part of the calendar with Ms. Kim.
Let's let the jail tell us what can we do not to make it too difficult for you. Either courtroom 2 or 3, do you all want to just go to the breakout now that we have our interpreter, or what's going to be easiest for you guys?
Yes, Judge, you can do the breakout in courtroom 3 while we do all of Kim's cases in courtroom 2.
Okay.
Okay.
All right, I think Ms. Lewis is organizer of all of that.
Okay.
How do you pronounce your last name? Okay. Also, sitting in front of you, Judge, is position 8, Mr. Joint.
Okay. Oh, 8 is the breakout one, correct?
That's correct, Your Honor.
Okay.
Well,
That's not the one that needs the interpreter. That's just a breakout to discuss the facts of the case, correct?
That's correct, Your Honor.
Okay, so put us in the breakout, Ms. Lewis, for position 8, and then I'll come back and give him my ruling.
Yes, ma'am.
So before you do that, it did say he was recommended, but due to history, he's not recommended.
Okay, he's not.
That's why, due to history, yes.
Okay.
And please put Deputy Falk in there as well.
First of all, who all needs to go in the breakout room? I just want to make it clear. So it's Reed, Falk, Judge, Kim, and who else?
Anyone with you, Kim?
Okay.
Estoy en corte. Estoy en corte. ¿Con quién? Estoy en la corte, en la computadora.
All right, Mr. Joint.
Yes, Your Honor.
All right, this is case number 22 CR 006017J. We have discussed the two charges in your case, the harassing communications being the first charge and the electronically transmittal in the second charge. And out of caution and protection of the victim, and I'm assuming I don't have a victim or anyone else regarding this case of Mr. Joint on the Zoom, just making sure that I do not, doesn't appear that I do. But I'm going to give my ruling because we needed to discuss that in a breakout, Mr. Joint. And I'm going to order a $10,000 surety bond, $5,000 on each charge. I'm going to order, Mr. Joint, please hear me clearly, that you are to have no further contact with the victim, Mel Monclier, or the victim, I think it's Odinel Fortune or Mr. Fortune. You are to not have any, and I mean any type of contact with either of those victims. There's language in our bond order that you're to stay 200 yards away from each of those victims. You're to not contact them at all through their family members, directly or indirectly, by any associates, any co-workers. You're not to contact either of them by phone, mail, email, pager, or any other writings, signs, notes, or messages through Facebook, through Instagram, through anything electronically. If you in any way have any contact with them, we'll bring you back down to the jail. And that 200 yards staying away from each victim, I'm very serious about that. I understand that you have a daughter with Ms. Monclier, and you're to have no visitation until you have a legitimation order in place with the parenting plan or visitation schedule. If you don't have that, then there will be no visitation. Once you do have that order in place, even then, I'm going to order that that visitation be facilitated by a third party or supervised, just to protect, again, the victims in this case. I'm going to also order no drugs, alcohol, or weapons while on bond, except for any medications prescribed to you. And I just hope that this stops. And again, I think that's all that I need to take up. Was that it, counsel?
May I please have a clarification about the supervision? Is it gonna be just while the kids are transferred, or even after they are transferred to the defendant, does he have to have a supervision of third party?
While he's on bond.
Okay.
Yeah, just while he's on bond. I don't think I would be so much in control at that point. You know, once if the case is over and he's not on bond,
Sure.
then I won't go further than that.
Okay, thank you.
All right, anything else from the state? All right, that will conclude.
Got a question.
Excuse me, Judge.
Yes.
Just want to make sure there's no further contact with her coworkers or acquaintances as well.
Yeah, and I put in there because the language says not to have any contact directly or indirectly with any victim or the victim's family members, professional, personal, close associates.
Okay.
If
that covers it. I appreciate it.
It should cover it. Ms. Bridgewater, if she wants to say co-workers, employers, she can throw those words in there just to make sure that it's clear, since we know that that's part of the allegations.
Right. Thank you.
Okay, thank you.
Mr. Joint, unless you have a question directly about the bond, please stay silent. I'll call you and explain everything.
Yes, I do. It's about the bond.
I'll explain it to you. Judge, you can go to courtroom 3 for interpreter case, position 6.
Okay. All right, this is 22 006019D, Wilmer Enriquez. And Madam Interpreter, can you raise your right hand for me, please? Do you affirm that you will faithfully interpret, and I didn't ask, this is Spanish to English?
Yes, Your Honor.
Spanish, that you will interpret the proceedings before the court in an accurate manner and to the best of your skill and knowledge with no embellishments?
I do, Your Honor. And Your Honor, may I please ask everybody to pause so I can interpret and to, make a short U-turns. And sometimes on Zoom, the audio is not that good and it's better to go short than to have to repeat something that is long.
Yes, that is a reminder for me as well, because we kind of forget to slow down for you. So I will do my best as well.
Thank
And I think we have 5 charges here in this case. So I called the case. Do you want me to say that again? So you can do.
I can say, Your Honor, I have the information. Ahora estamos enfrente con el caso del señor Enríquez Wilmer, el caso 22CR006019D, y hay varios cargos.
You are charged with 5 counts.
Lo acusan de 5 cargos.
The first count being DUI less safe.
El primer cargo es manejar bajo los efectos del alcohol, que lo hace menos seguro o apto para manejar.
Second count, driving possession of open alcohol container.
El segundo cargo es manejar con un envase abierto de bebidas alcohólicas.
Third charge, expired or no license on person.
El tercer cargo es tener una licencia o tener una licencia que está vencida.
Fourth count, driving improper or erratic lane change.
El cuarto cargo es manejar de una manera errática cuando hace el cambio de carril.
And fifth count, of failure to report striking a fixed object.
Y el quinto cargo es no informar acerca de haberle pegado a un objeto fijo.
All with the offense date on September the 6th, 2022.
Y todo esto ocurrió el 6 de septiembre del 2022.
Pre-trial.
Conferencia previa al juicio.
First arrest.
Es el primer arresto.
Yours was good and short. Okay.
That was good.
How often is it that short?
No, not often. That is correct.
I'm the lucky one today.
Okay. All right. Go ahead, ASG Reed. We got your back. Good.
I'm back. Sorry about that. Thank you, Judge.
All right.
Officers received a call that a driver went into a ditch.
Los agentes recibieron una llamada que un conductor se metió en una zanja.
Near the area of 1580 Holcomb Bridge Road.
Cerca de el 1580 en Holcomb Bridge Road.
A witness told the officer that the defendant was traveling eastbound.
Un testigo le dijo a los agentes que el acusado estaba manejando, iba rumbo al este.
And the witness told the officer the defendant's vehicle overcorrected and drove off the road.
Y el testigo le dijo al oficial que el vehículo que estaba manejando el acusado sobrecorrigió lo que estaba haciendo, entonces salió del camino.
Into flower bed and bushes at the Park 83 apartment complex.
Y se metió contra unas flores y sobre unos arbustos en el complejo de Park, en 83 Park, el complejo que estaba ahí.
Officer approached the vehicle and saw the defendant in the driver's seat.
El agente se acercó al vehículo y vio al acusado en el asiento del conductor.
The officer saw damage to the vehicle with a side passenger mirror missing and the entire passenger door missing.
El agente vio que había daño y vio que había el espejo que estaba del lado del pasajero, la puerta del pasajero estaba dañado y también toda la puerta del pasajero no estaba.
The officer saw a broken side window with fresh glass in the car and on the defendant's arm.
Can you repeat that for the interpreter, please?
Yes. The officer saw the broken window with fresh glass inside of the car and on the defendant's arm.
Entonces el agente también vio que había el vidrio de la ventana estaba roto, estaba recientemente roto y estaba en el brazo había caído en el brazo del conductor, del acusado.
The officer saw 8 beer cans in the car and one 24-ounce beer with liquid inside that was still cool to the touch.
El agente vio 8 latas de cerveza y había una lata de cerveza de 24 onzas que todavía estaba abierta y que se sentía que estaba todavía fría cuando se tocó la lata.
The officer tried to communicate with the defendant using a language line.
El agente trató de comunicarse con el acusado usando una línea por teléfono de español.
The defendant said he was coming from a friend's house.
El acusado dijo que venía de la casa de un amigo.
The defendant said he did not have a driver's license and he lived in the United States for about a year.
El acusado dijo que no tenía una licencia para conducir y que había estado viviendo en los Estados Unidos desde hace 1 año y unos meses.
During the conversation, the defendant supported his body weight on the car.
Durante la conversación, el acusado estuvo aguantando el peso de su cuerpo en el carro, en contra del carro.
Due to the language barrier, the officer did not conduct a field sobriety test.
Debido a la barrera de idiomas, el agente no llevó a cabo ningún tipo de pruebas de sobriedad en el campo.
Defendant was placed into custody and the officer read the implied consent notice.
Al acusado se le arrestó y el agente lee el consentimiento implícito de este documento de notificación.
Judge, although this is defendant's first arrest, the state is concerned that he does not have strong ties to the community.
Aunque este es el primer arresto del acusado, la fiscalía está preocupada y tiene preocupación porque este acusado no tiene ningún tipo de vínculos ni ataduras a la comunidad.
The state is also concerned that he's driving without a license, and in this instance, his driving was dangerous and he could have seriously hurt himself or someone else on the roadway.
También está preocupado porque esta persona, el acusado, está manejando sin licencia, no tiene licencia, y en esta ocasión también está preocupado de que pudiera causarse daño él mismo y a otras terceras personas en la comunidad.
The state is requesting a split bond, which will be $2,000 surety bond for count 1.
También estamos pidiendo que se haga una fianza dividida, que sería $2,000 por un fiador en el cargo número 1.
$500 surety bond for count 2 and count 3.
El cargo número 2 y 3, $500 también con una compañía de fianzas.
A $500 signature bond for count 4 and count 5.
Y por los cargos 5 y 6, una fianza de bajo palabra de $500.
That's a total of $3,000 surety and a $1,000 signature.
Con un total de $3,000 de una fianza de caución y $1,000 por una fianza bajo palabra.
Nothing further.
No tengo más de qué decir.
All right. And this is Mr. Bartlett.
It's my case. Yes, thank you, Your Honor. I've spoken with Mr. Enriquez.
Yo hablé con el señor Enríquez.
And what I'm informed, well, he is 22 years old.
Él tiene 22 años de edad.
And he is, I'm told, employed full-time with a tree cutting company.
Y él está trabajando a tiempo completo con una compañía que corta árboles.
So he is gainfully employed. I'm told that he has been in the Atlanta area for over 1 year.
Y me dijo que está viviendo en la zona de Atlanta la zona de Atlanta por 1 año y él tiene un empleo que es remunerado.
And he has also given me the name and number of an acquaintance, a friend of his, who would be willing to post bonds. So he does have ties to the community. That would be our position.
Y él también me dio el número y el teléfono, la información de un amigo, que una persona que puede pagar esta fianza. Por lo tanto, ahí estamos demostrando que él sí tiene vínculos o ataduras a esta comunidad.
And we understand this is not an evidentiary hearing or a trial, but he did indicate to me that there was another driver that ran into him and caused him to lose his lane.
También estamos entendiendo que esto no es una audiencia para presentar pruebas ni para hablar sobre presentar pruebas, sino que pero también él me comunicó a mí que hubo otro conductor que lo hizo, causó la parte del accidente porque se le metió hacia él.
And as pretrial has indicated, he does not have a criminal record.
Y como indicaron en la conferencia previa al juicio, no ha tenido ningún otro antecedentes penales.
And the report I have says that he meets the criteria for unsecured judicial release.
Y el informe que yo tengo dice que cumple con los requisitos para que se le pueda dar una libertad judicial.
So based on all that, we would ask the court to consider a signature bond.
Y basado en todo esto, le pedimos al juez que considere una fianza bajo palabra.
And if the court is not inclined to do that, we would ask for $1,000 good bond on count 1.
Y si el juez no tiene la intención de hacer esto, pedimos que se le dé una fianza de $1,000 por el cargo número 1.
And the $250 good bond on counts 2 and 3.
Y en los cargos 2 y 3, una fianza de $250.
And then the signature bonds on counts 4 and 5.
Y las fianzas bajo palabra en los cargos 4 y 5.
So that would be $1,500.
Eso sería una fianza de $1,500.
All right,
That's it.
okay.
Okay.
All right, I'm going to order the split bond.
Voy a ordenar la fianza dividida.
On the first count, that will be a $2,000 surety bond.
En el primer cargo van a ser $2,000 de caución.
Counts 2 and 3, $500 surety bond each.
Y que para los cargos 2 y 3 van a ser $500 de caución para cada uno de estos cargos.
For a total of $3,000 surety bond.
Para un total de una caución de fianza de $3,000.
On counts 1 through 3.
En los cargos 1, 2 y 3.
And then on counts 4 and 5, $500 signature bond each.
Y en los cargos 4 y 5 son una fianza bajo palabra de $500 cada una.
Which would, oh, I already said that.
Que ya dije el
So
total.
do you have that, Miss Bridgewater?
I do, but is that signature bond through the
Jail.
jail or how? Through the jail?
Yes.
Got it.
Okay.
Okay,
So that's a total of a $4,000 split bond.
Correct.
Am I correct? Okay,
Yes.
got it.
And no drugs, alcohol, or weapons while on bond.
No puede tomar, ingerir drogas ni alcohol, y tampoco puede tener armas mientras sale bajo fianza.
And obviously no driving unless he has a valid driver's license from DDS.
Y por supuesto no puede manejar a menos que tenga una licencia válida del Departamento de Servicio al Conductor o DDS,
While on bond.
mientras está bajo fianza.
All right, does that conclude everything, council?
Eso es
That
todo.
is it for us, Your Honor. Thank you.
Eso es todo.
Thank you,
Right, thank
Judge.
you.
May I be excused, Your Honor?
Do we have another one? I thought we had two. No,
Oh, okay,
let's see. Let me make sure.
sure.
She's in courtroom 2.
Okay, we have a second case in courtroom 2.
Oh, okay.
Thank you, Madam Interpreter.
Oh, you're welcome.
Surety bond, surety bond, surety bond.
I'm sorry, Judge.
Yeah,
Bond amount for position of
Well,
the case so I can relay the message.
Right.
for position 6.
$2,000.
I've got two people talking. Couldn't hear you.
For the interpreter case, can I?
Oh, yes, on, it's a split bond. And then counts 1, $2,000 surety bond. Counts 2 and 3, 500 each surety bond. So a total of $3,000 surety bond on counts 1 through 3. And then counts 4 and 5, $500 signature bond on each through the jail, or $1,000 signature bond through the jail.
Okay, so 3,000.
Right, 3,000 good, 1,000 signature through jail.
Okay, thank you, Judge.
All right, no problem. So we don't have a second interpreter case?
No,
Oh, okay, I'm sorry.
no problem, Judge.
Okay,
Okay.
all right, Madam Interpreter, you are released. Thank you so much.
You're very welcome, Your Honor. Have a
All
great
right,
day.
thank you. You too.
Position 14, Williams.
This is case number 22 CR 0060009A. Lakia Williams, you're charged with 1 count of battery and a 2nd count of theft by shoplifting, both with the offense date of June 16, 2022. Pre-trial.
It's a 5th arrest. 2019 FTA conviction out of Henry County. It doesn't give an underlying charge. 2019 driving without a valid license. And 2000 arrest out of Maryland. False statement to officer. I put SOB jail. I didn't see the battery. I just thought she was charged with shoplifting. So I'll take her.
Okay.
All right.
All right. ASG Mitchell.
Yes, Your Honor, in this case, the defendant battered a Circle K gas station employee, Mr. Amin, spelled A-M-I-N, Kuchi, spelled K-U-T-C-C-H-I, by striking him in the face several times, leaving his face swollen. The defendant regularly comes into this Circle K located on 1892 Howell Mill Road, Northwest, Atlanta, Georgia. She walked in with an empty cup, refilled her cup at the fountain drink area, and walked out of the store without paying for it. Mr. Kuchi stated she's done this several times before, and he decided to confront her this time about not paying for the drink. He attempted to take the soda from her, and it spilled. That's when the defendant chased Mr. Kuchi back into the store, cornered him as he fell onto the floor, and then got on top of him and punched him several times in the face. She went back to the car and grabbed the empty cup to refill it again when Mr. Kuchi called the police at that time. Your Honor, the state's bond recommendation is going to be as to count 1, a $3,000 surety bond, count 2, $500 surety bond, totaling a $3,500 surety bond, no further contact with the victim, Mr. Kuchi, a stay away from the incident location, Circle K, located on 1892 Howell Mill Road, a 1-day anger awareness, and no alcohol, drugs, and weapons. We do have concerns of defendant's risk of reoffending, being that the victim stated that this has happened before. The defendant also beat Mr. Kuchi over a drink, and that violent nature gives us reason to believe a surety bond is appropriate in this case. We also do have flight risk concerns, being that she does have an FTA in 2019, which is fairly recent. So with that being said, we are recommending the $3,500 surety bond. Thank you.
All right. Ms. Kim?
Yes, Your Honor. Miss Lakia Williams is 47 years old, Your Honor, actually. And she has been here in Georgia for about 4 years. She moved from Washington, D.C. And she has, after her both parents passed away, and she wanted to have a different place where her parents were not continuously reminded. She is a self-employed barber. She has been a barber for about 30 years. She has 2 years of associate college degree from Howard University, and she actually has a special medical condition that she cannot expose to cold air too much, and it's too cold right now in the jail. She was arrested on Friday, and she was in another jail, and then yesterday she was transferred to Fulton County Jail. So total, she has been already in jail for 5 days. And this happened on June 16, 2022, almost 3 months ago. And Your Honor, apparently, the reason my client denies the allegation, and also indeed I recommended her to file a claim against Mr. Amin Kachni, who has been very discriminatory to Miss Lakia Williams because of her race and also her sexual orientation. There was a very bad words that he used, and I would like to, I cannot sound here, and those were very mistreating, and a lot of stories. It was him who fell down. It was not her who hit him. So we would like to request for signature of bond, and pretrial is willing to take her. I think she is qualified for signature on bond, Your Honor. Thank you.
Your Honor, if I may, I'd like to add that there was also a video of the incident that occurred. Nothing further, Your Honor.
All right.
We had no chance to review the video, Your Honor.
All right. All right, I'm going to issue a $4,000 signature bond through pretrial. And that breakdown will be $3,500 on the battery and $500 on the theft by shoplifting, for a total of a $4,000 signature bond through pretrial. I'm going to order the 1-day anger awareness course through pretrial. No drugs, alcohol, or weapons while on bond. Stay away from the Circle K at 1892 Howell Mill Road. No further contact with the victim, Mr. Amin Kuchi. And no drugs, alcohol, or weapons while on bond. Anything else that I need to take up?
Nothing further, Your Honor.
No, Your Honor, thank you.
All right.
Thank you.
Next judge, position 9, person.
All right, this is 22 CR 006020Y. Clifford Person, you're charged with 1 count of battery, a 2nd count of simple assault, both with the offense date of August 17, 2022. Pretrial.
12 total between Georgia and New York. Last arrest was back in April, a weapons offense. He got an open case in Superior Court, burglary in the 1st, felony theft by taking, criminal damage to property 2nd degree. It's 22 CP 208291. Got another open theft by receiving, possession of a firearm by convicted felon, giving false name, 21 CP 201591. Hold on. All right, I'm gonna go to the New York district.
Okay.
All right, last arrest in New York was in 2020. It says aggravated unlicensed operation, criminal impersonation, driving while intoxicated. Another 2020, criminal possession of a loaded firearm, criminal possession of a weapon, 3rd degree, harassment, 2nd degree. What else? 2018, resisting arrest, unlawful fleeing an officer. 2018, grand larceny, 3rd degree. That was a conviction. Before that was 08, criminal possession of a weapon. I'll leave it at that. I'm done.
Okay, thank you. ASG Duncan.
Yes, Your Honor. In addition to what pretrial stated, I did want to note for the record that this defendant's GCIC did indicate from New York history that there are open bench warrants on file with their courts. I'm not sure which cases those belong to, but I know that grand larceny says sentence pending, and the 2 2020 arrests for unlicensed operation along with other charges did not have a disposition. I also noted a Georgia, April 2022, felon in possession of a weapon from the U.S. Marshals with no disposition, in addition to the 2 open cases. I want to start by saying that these cases are currently on a $20,000 surety bond. That's $10,000 per charge. The state is going to be requesting that the bond remain as set. In this case, Your Honor, we have a concern about the risk of reoffending, the intimidation of the particular witness We also have a concern about this defendant's ties to the community and him being a danger to the community as well. This incident did occur on August 17th, 2022 at the Harrison Apartments located at 5675 Roswell Road in Sandy Springs. Officers encountered the victim walking to the gas station. They noticed that at the time he had several very visible injuries. He stated to officers that he was chased down by the victim who was driving a red Jeep with a New York tag. And at that time, the defendant exited that vehicle and began striking him. The victim, my apologies, Mr. William Nash, both common spelling, displayed injuries to both elbows. EMS on the scene indicated that they believed that the elbow injuries were gunshot wounds. He had injuries to his legs and he was complaining about abdominal pain. In this instance, Your Honor, there was an independent third-party witness who saw the defendant in this case chase down Mr. Nash with his car, as well as get out of that car and began to stomp and strike the victim, in this case, Mr. Nash. However, the view was obscured as to how he received the elbow injuries, but the witness did indicate that there was her vision of him getting out of the car and attacking this victim. The victim, Mr. Nash, was taken to a hospital for further treatment of his injuries, given the severity that the EMS on scene indicated. However, he did not receive treatment at that time. The state has a concern here. We're not even necessarily sure that this defendant is supposed to be driving. He was seen getting out of a vehicle, given the open cases in New York for unlicensed operation and his violent history towards others. In that 22 CP 208-291 case, he was released on a $10,000 surety bond less than 4 months prior to this instance, Your Honor. So in addition to all the other IL factors present, we do have a concern about this defendant's likelihood to respond to the legal process. The witness did indicate at the time she saw the defendant jump out of the car, he was wearing an ankle monitor while perpetrating another violent offense, in addition to those that he has open with Fulton County Superior Court. So given those facts, Your Honor, we think that the $20,000 surety bond, $10,000 for each count, is more than reasonable, and we request that it remain as such, that this defendant have no further contact with William Nash, that the defendant stay away from the entirety of the Harrison Apartments located at 5675 Roswell Road. We know that the facts indicate that he apparently may live in those units. However, we're concerned we don't know exactly where the victim lives in that complex, so because we weren't able to make contact. So we're just going to ask, out of an abundance of caution, given the nature of the injuries and the attack as alleged, we'll ask that he stay away from there. We're going to additionally ask for 2 weeks of anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law. Given all these things and the suspected injuries and visible injuries to the victim, we think that the $20,000 surety bond is more than reasonable with the other conditions as stated. Nothing further from the state.
Okay. All right, Ms. McLeod.
Yes, Your Honor. My client is 34 years old. He tells me that he moved to Atlanta from New York over a year ago, and he does live in Roswell. He lives in that apartment complex. He lives there with his girlfriend. I did not hear the state say specifically that the alleged victim lives in this apartment complex, and to ask someone to stay away from an entire apartment complex without knowing that the alleged victim lives there seems a bit unreasonable to me. While we acknowledge that my client does have some history, this charge is not related to the history that he has. He denies knowing the alleged victim at all. In the facts as narrated by the prosecution, it doesn't give any reason, or the victim doesn't say why he would have encountered my client and why my client would have attacked him. So it just begs the question as to the accuracy of what the alleged victim is saying and whether or not this was in fact my client. He denies any such thing, and he doesn't know this victim. He tells me that the police came to see him before about this and determined that he was not the correct person. So they let him go, and they have come back on this. But I think there is an issue, certainly as to his identity in this, Your Honor, and he denies that it happened. Setting a bond of $20,000 is not reasonable under the circumstances. We are talking about misdemeanor charges, not felony charges, and to say $10,000 on each charge is unreasonable. I would ask the court to set a bond that is reasonable based on the allegations, based on the fact that my client denies them, based on the sketchy allegations made by the complaining witness. Thank you, Your Honor.
If I may, Your Honor, just quickly to clarify for the record and for the defense, I did actually state that the victim in this case, Mr. Nash, is a neighbor and that this incident did happen in their apartment complex, but we don't know exactly where they live. This witness, there was a third-party independent witness, so we're not just going off of the statements made by the Mr. Nash in this case. There was a third-party witness who identified the defendant in this case by the unique clothing that he was wearing at the time of the incident, which is the same clothing he was wearing when he was approached by officers, as well as being identified by the type of car and the license plate that was attached to the car that he was driving at that time. Your Honor, we think that the $20,000 surety bond is more than reasonable, given that this defendant has 2 open cases in Superior Court that deal with violence or weapons in some nature, and possible open cases out of New York State as well, Your Honor. All the factors are present here, and given the alleged injuries, we think it is more than reasonable at this time that the bond remain as set and the court approve our recommendation as stated earlier on the record. Nothing further from the state.
All right.
Nothing further, Your Honor.
Okay. I'm going to order the $10,000 surety bond. That is $5,000 on each charge. I'm going to order a stay away from 5675 Roswell Road. And give me the name of the apartment complex.
The apartment complex is the Harrison Apartments.
Okay, the Harrison Apartment. Stay away from the whole complex. I'm going to order no further contact with the victim, William Nash. And no drugs, alcohol, or weapons while on bond, except for those prescribed to you by a doctor. And I guess on the anger awareness course, I'll wait on that. I don't know what his finances are. I think Ms. McLeod said he was working.
Yes, Your Honor, he does work, but his finances are not like that because he's working with his girlfriend. They're trying to set up a business. So the money is not flowing like that yet because it is new.
Right.
Mr. Persons, unless this is about your bond, my advice to you would be not to speak. Is it about your bond?
No, ma'am.
Well, my advice to you is not to say anything, because anything that you say can be used against you, not only in this case, but in any other cases you may have pending.
It's not about the case, it's about the lease on that, the apartment.
Does he live there? Does Mr. Person live in this complex?
He does, Your Honor.
They both live in the complex, Your Honor, but we weren't able to make contact with the victim, and given the nature of the offenses alleged and the injuries, we're going to ask for a stay away for his safety.
I do agree. I'm concerned about the allegations, Mr. Person. You're gonna have to find somewhere else to go live.
And if in fact they don't know each other, as the defense may have mentioned, we would think that the anger management is appropriate if this was a random attack of violence on a stranger. So if Your Honor is inclined, we would just request that, but if not, we would defer to the court.
Right. I do understand. I have sometimes, been finding the course and taking it outside of pretrial can be difficult. So I'll hold off with the course for right now. They can order that later in the case.
Understood.
Okay. All right. Thank you, ladies.
Thank you.
Thank you, Your Honor. Your Honor, that concludes my business before the court today. May I be excused?
Yes, you may. All right. Thank you.
Thank you. You're welcome.
Position 13, Williams.
13. Okay. This is the one I need a breakout on. I think I saw in the chat.
Yes, Your Honor.
Okay. Need a breakout, ASG Mitchell, Kim, Falk. That's it, I think.
Ms. Lewis,
Yes, sir.
is there a way you can call extension 22392?
Extension 22392.
Yes.
Yes, I can.
All right, thank you.
All right, we're back on the record. And we're back regarding position 13 with Giovanni Williams. This is 22 CR 006008B. Mr. Williams, you're charged with 2 counts of, I'm sorry, yes, 2 counts, 1 count of simple assault, second count simple battery. And that is you, Mr. Williams? Shake your head.
Yes, Judge.
All right, Mr. Williams, I'm going to order a $4,000 surety bond in your case, $2,000 on each of the charges. But also, Mr. Williams, I'm going to order no further contact with the victim, who is a juvenile minor, AG, just giving the initials. But I have some grave concerns that I want to go over with you. First of all, you are to stay away from Booker T. Washington High School at 45 White House Drive, and understand that should be a bond condition that you can comply with right now. Also, I'm very concerned about some of the allegations in this case. And so in our bond orders, we have language that I want to make sure that you are clear with, Mr. Williams. And that is that you are to not have any type of contact with Mr. AG. And that is mainly by third parties, other persons, family members, friends, relatives, any other classmates. You are to stay 200 yards away from AG. You are to not get on any social media sites, any emails, any indirect contact through other people, or else we will revoke your bond and bring you back if you make bond. So I want you to be very clear that you are not to do any additional postings or talking about this case on any social media or computer platforms. Is that clear? Okay. And you got to shut it all down right now, because I understand there's a video out there and it may be in the social media world. All of that has got to stop, and certainly not be any additional allegations against you for putting any of that information out there. And if you are to see AG in the neighborhood or the community, you're to stay 200 yards away and make sure that you have no direct or indirect contact with the victim. Is that clear? All right. No drugs, alcohol, or weapons while on bond, except for anything prescribed to you. And that will be the ruling of the court. Anything else, counsel, that I left out?
No, Your Honor, thank you.
Okay, thank you.
Judge, quick question. There's a third charge on his 3 card, the theft by receiving stolen property. Has that been dismissed?
Oh, I was not aware. ASG Mitchell, is there, or Deputy Falk, is there a third charge?
I'm checking now, Your Honor. I was not aware of a third charge either. It may be a felony charge, but let me check and see.
Okay.
Thank you.
Yeah, his theft by shoplifting is a felony.
Okay, thank you. Okay, have a seat.
It does have a 20 CP number on it, so it actually is a rearrest from a previous offense.
Oh, okay.
For FTA, I guess.
Or an FTA.
Yes, because he didn't get the notice of hearing.
Great. Great. Thank you.
I have an issue of taking back up position 1. Has Mr. Butler come back to the courtroom yet?
For Mr. Butler, he's already out the courtroom, Judge. Did you need him?
I think we do. He was already taken back to his cell.
Yes, Judge.
We do have an issue. If you could order him to come back.
Okay.
Okay, and then we'll come back to him once he's back in the courtroom to let me know.
And if we're going to revisit that case, I will need to speak with him again in a breakout room or a private phone call.
Okay. All right, just let us know, Deputy, when he's back so he can speak to his attorney first.
And the victim on that case is in the waiting room waiting to be let in.
Okay.
This is position 4, Mr. Gray.
This is case number 22 CR 00601. I'm sorry, 6013G. Deontay Gray, you're charged with 1 count of battery family violence. The offense date is May 30th, 2022. Pre-trial.
This is 10th arrest. Last arrest was July 1st. Ag assault DV, that's open. 2015 battery DV, NOD. 2015 ag battery, ag assault, they were dismissed. And the firearm charge. 2014 battery DV was non-pros. 2013 battery DV, cruelty in the second. I don't know what the disposition is of that. 2010 battery conviction, felony obstruction conviction. That's it.
Okay. All right, ASG Duncan.
Yes, Your Honor, this incident occurred on May 30th, 2022 at 4555 Washington Road in Atlanta. That is the Gardens at Kent Creek apartment home. In this case, Your Honor, the defendant was arrested by the U.S. Marshals. It's indicated in the warrant that he punched his child's mother, Miss Brittany Grooms, in the mouth with a closed fist, resulting in her having a busted lip and a laceration on her right hand. As pretrial stated, this defendant does have several previous arrests for battery family violence, as well as convictions for violent offenses in his history. So here we have a concern about the risk of reoffense. Given this history, we see that this defendant does have somewhat of a violent nature. We have a concern about intimidation of the witness. We are not aware of their relationship status. However, we do know that they share a child. So sometimes that can come into play when determining whether or not the witness is willing to proceed with prosecution. Speaking of that, we were not able to make contact. We also have a concern about this defendant being a flight risk. We located in the record a 2015 bench warrant for a battery family violence case. It was NOD'd, however, it does give us some concern. And we do have concern about this defendant's likelihood to respond to the legal process. Because this defendant clearly has been arrested several times for violent offenses, as well as has an open aggravated assault domestic violence case in Superior Court right now, in which she received a $2,500 good bond. It's not the same victim. However, as stated, we have concern that it shows a risk of reoffense. In this case, we're asking for a $5,000 surety bond based on the history of violence and the open case involving shooting another person. We're asking for no further contact with the victim in this case, Ms. Brittany Grooms. Third-party child contact, stay away from the incident location, 4 weeks of anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
And you said there's third-party
child transfer.
Okay.
And we are not aware of who the child is in that 2013 battery family violence. As this is an active case, if we find out other information, we'll put that in the file. But that 2013 case, which is battery family violence and cruelty in the first, we don't know what happened to that either. But
I believe that was dismissed. I've looked in Odyssey.
We're not exactly sure though. However, we just stated that it says bind over, but in saying that, Your Honor, we don't know that it's their child that they share together. So we're going to request for a third-party contact at this time.
And I guess Mr. Bartels, I don't know if you have any additional information.
Well, yes, Your Honor. Well, just to let everybody know, the alleged victim, not the complaining witness, but Ms. Grooms, she's not the one that actually called the police. She is present, Brittany Grooms. I believe I see her name. I did have, I was able to contact and speak with her. I'll get to that in a minute. Mr. Gray is 36 years old. He is employed full-time. I'm advised that he works at GXO Solar, which is a warehouse in Union City. So he works full-time. I'm advised that he financially assists Ms. Grooms as well as the two children they have together. He also has both of his parents, I'm told, his aunt and his siblings all live in Atlanta. So he does have ties to the community. If I recall, I checked Odyssey. It appeared that one of the battery case was null pros. It looks like the battery charge that was a part of the obstruction, I believe he pled to the obstruction, but it looks like the battery charge in that case was dismissed as well. So we would ask the court to take into account all of that in setting a bond. I did speak with Ms. Grooms. She told me, and I know that I don't know if she wants to address the court, but she advised me that she was not in fear of her safety and that she was asking for a no further violent contact order rather than a no further contact, since they do have children together, they live together, and he is helping her financially. Regarding the bond, I do have the pretrial report. It says that he does not qualify, for unsecured judicial release, but it also says he does not have 2 or more FTAs, does not have 3 or more probation violations, has not been convicted of 2 or more violent offenses within the last 10 years. So given all of that, we would ask for a $1,500 good bond.
All right. Ms. Grooms, do you wish to address the court? If you do, you can turn on your camera. I see that you're unmuted. Would you like to address the court or not? If you don't have to turn on your camera. But you can at least let me know yes or no.
I can try to call her, Your Honor.
Yes, she may be having trouble. Ms. Lewis, can you tell? Unless she's frozen.
And Your Honor, if I may, while we wait on her to fix her connection, I just want to state for the record that this defendant does have 1 violent conviction. However, he has 3 other violent arrests and an open aggravated assault case in Superior Court right now, as previously stated, where he received a $2,500 good bond. So we think that the $5,000 surety is more than reasonable given this defendant's risk of offense and his violence in the history. Nothing further.
Okay. Well, if we can't get her on, as soon as I move on, she'll come on. That's how it usually goes. Then we'll just kind of keep moving. Ms. Lewis?
Let me see what's going on with Ms. Lewis. 1 second.
Okay, because she may be talking to her, helping her to get on possibly.
And Your Honor, we also have position 1. The victim on position 1 is still in the waiting room. I tried to reach out to the host and I haven't gotten a response.
Same here. Hopefully Ms. Bridgewater will. I see an iPhone 11 connecting.
Is that her that on the phone that just says iPhone? You really can't.
She may have had a bad connection as well. Who's iPhone 11?
That is me, Kim Butler.
Okay.
I tried calling Ms. Grooms and the call would not go through. I just got like a beep. So she may be having connection.
She may be having connection issues. And then what about
the person name that y'all looking for, Ms. Groom?
Yes.
She just got in the waiting room. I just clicked on her, let her in. She's been popping on and off on the Zoom.
Oh, she's been going on and off. Okay.
I just clicked on her to let her in the Zoom room and she went off.
Yeah, but if she comes back, Go ahead and let her in. And I see
I have
iPhone.
no problem letting them in, but if they're not in the Zoom thing, you
Right.
know, I can't
Yeah,
let
I
them in
understand.
if they're not in the waiting room.
Yeah, I see Brittany Grooms again, and
Ms. Grooms, can you hear us?
Do they have the right link?
say that again, Ms. Lewis.
Do they have the right Zoom link, the right passcode?
Oh,
You could be on Zoom, but if you don't have the correct passcode to get
it's
in,
not going to allow you to get in.
it won't
Correct.
allow you to get in, or you could be typing somebody else's passcode and you could say waiting for a host and you're in a totally different.
Gotcha.
Yeah, that's correct.
Well, I'll go ahead and rule on this case because we're going to have to go back to position one. And that, you know, I needed the victim in position one, which was Ms. Butler. So I hope I can at least get Ms. Butler back. I'll go ahead and make my ruling on position four with Mr. Gray. Anything else from council?
Nothing at this time, Your Honor.
Nothing further, Your Honor.
All right, I'm going to go ahead and issue a $5,000 surety bond. I'm going to order a stay away from the incident location, which is 4555 Washington Road, the gardens at Camp Creek Apartments. I'm going to order, Ms. Grooms, are you back with me? Okay, I'm going to order no further contact with Brittany Grooms. And if there's to be
She's
visitation.
on the line, Judge, but I don't know why she's not answering. I see her.
Okay, Ms. Grooms?
Ms. Grooms?
Yes, there you go. Ms. Grooms, can you hear me? Ms.
Okay,
Grooms?
yes, I can hear you.
Okay, there you are. Well, do you wish to address the court real quick? I'm ready to give my ruling.
No, ma'am, it was a misunderstanding. Me and my son.
No. If I ask you, do you wish to address the court, you say no, then you start talking. So can't have it both ways, yes or no. And if you do, I need to swear you in before you talk.
Okay, no, ma'am.
Okay, all right. So I'm going to go ahead and give my ruling. Let me ask you one question, Ms. Grooms. With Mr. Gray, there is one or two, how many children do you have with him? Did she go back off?
Yeah.
I think we lost her again. Looks like she might have been in a car.
I'm told that they have 2 kids together, Your Honor.
Okay, it's 2 children. Okay. All right. And I was going to ask her were they legitimated or not, because I'm going to start kind of using that as far as visitation goes so that we don't have some issues of violating the bond conditions. So I will add that bond condition because of the allegations in this case that if there's visitation allowed with the 2 children and Mr. Gray, that they be legitimated first with a valid parenting plan or visitation schedule, and then that will be facilitated by a third party once there is an order and legitimation conducted or ordered for the 2 children, just to make sure that their safety will be a little bit better assured here. No further contact with Brittany Grooms. I'm going to order no drugs, alcohol, or weapons while on bond. And again, that's a $5,000 surety bond. And I think that is it. Anything that I've left out, counsel?
Nothing else from defense, Your Honor.
Okay.
Nothing, Your Honor. Giving your sentiments about anger management at this stage.
I will not order it at this point, so maybe you'll get this legitimation order and visitation schedule first. Okay. All right, I think we're going back to position one.
Yes, Judge, I think Bartel needed to talk to him first. You can call him, Mr. Bartel, at 44612-2392.
612-2392. Okay, I will make that call now.
Okay.
And if I can mute.
Correct. All right, you're done.
And Your Honor, Ms. Butler is present. She's under iPhone 11, so when the court is ready to hear from her.
All right, Miss Butler. I see it now. I see a Kimberly Butler by name. She was able to fix her name.
I would ask that we just, if it's possible, wait until Mr. Bartel's obviously
Right,
comes back and
exactly.
break out. I just wanted to make sure everybody was aware she is here.
Yes. Although, okay, I was getting ready to say lost her again. I think some people are having some connectivity issues. Just hold for me, Miss Butler. Okay, there you go. Okay.
Can we do somebody else or everything is paused?
Yeah, I was getting ready to say we can't do the next three cases because they're all for Bartel.
They're not Bartels?
All of them are for Bartel.
Okay.
Can we do Mr. Vieras, Michael? We have a waiver of appearance. We can do him.
I usually like to get the others out and do our waivers last.
Oh, okay. No problem, Your Honor.
Who else do you have, Deputy?
Judge, everybody belong to Bartels except for him.
Oh, okay, well, that will circle back. I was gonna let you tell us someone else, Deputy.
No, Judge, all the cases that we have left is for Bartel.
Okay. All right, so we can do, you if you want to go ahead and do 12 then.
I have.
Since I have a waiver. You have that, Ms. Bridgewater?
Hang on just a
I
second.
do.
Your Honor.
I have the waiver.
Okay, well.
I'll tell you what, let's hang up. Everybody can hear everything we're saying. This is not a confidential,
No, you were muted at first, so if you could mute yourself, we cannot hear you.
okay, I guess I'm just concerned if Mr. Butler can be heard.
No,
I haven't been
no.
able to hear anything coming from the jail.
No, she's muted the
Came on.
courtroom.
Okay, I just need to
Yeah,
mute.
no, we could not hear you. Okay. No, he's not. Okay. Oh, because if we start another case, she will, no, she won't unmute if we do.
Nope, because it's
That's
the
right.
waiver with Mr. Vieras. So
Yeah,
if
let's go ahead and-
pre-trial can put on the record, I think we're ready to go.
Let me call 12 real quick, pretrial. 22 CR 0060076, Michael Vieras or Vieras. I have a waiver of appearance, 1 count of criminal trespass on 9/6/2022. What you got, pretrial?
14 total.
Okay.
Last arrest was 2020, possession of a Schedule 2 controlled substance, financial transaction card theft, and fraud. On probation in Cherokee County for that. 2019 simple battery trespass conviction. Probation violation. 2017 probation. Hold on.
Okay.
2017 battery DV battery conviction. That's it.
All right. ASG Mitchell.
Yes, Your Honor, in this case, the defendant continued to criminally trespass onto Lenox Square Mall located at 3393 Peachtree Road, Atlanta, Georgia. By re-entering the premises after being issued a criminal trespass warning from the reporting officer and head of security approximately an hour and a half prior to arrest. The defendant was on the property since before the mall opened and returned approximately 3 times while refusing to leave. Your Honor, there's a current bond of $2,500 surety, and the state requests that bond remain the same with a stay away from the incident location and no alcohol, drugs, and weapons. The defendant is a convicted felon. He does have an outstanding warrant for larceny out of Cartersville, and as heard from pretrial, he does have a variety of crimes in his history, mostly convictions, the latest being the 2020 conviction for possession of a felony drug and a prior criminal trespass conviction in 2020 as well. So we are requesting that this bond remain the same. Thank you.
All right, Ms. Kim.
Mr. Michael Vieras is 32 years old and he has been here in Georgia for 23 years. He has all his families here in Georgia, Your Honor. he also is gainfully employed and he graduated from college. We would like to request for signature on bond, and yet if your honor is not inclined to give him a signature on bond, we would like to request for a maximum $1,000. The bond, he has a foreign county warrant hold, so he has to be released only to Bartow County, and so there is no way that he's a flight risk at this point. Thank you, your honor.
Okay. All right, I'm going to go ahead and give my ruling. I'm going to leave the $2,500 surety bond in place. No drugs, alcohol, or weapons while on bond. And a stay away from the Lenox Square Mall, 3393 Peachtree Road. And that will be the $2,500 surety bond.
Yes.
Okay.
Thank you.
All right, thank you.
This is position 1, Butler.
All right. Ms. Butler, can you unmute yourself for me? Thank you.
Yes, ma'am.
Let me swear you in and I'll call this case 22 CR 006012J. Sanford Butler, you were charged with 1 count of simple battery family violence. I gave a ruling, I don't know, 15 minutes or 20 minutes ago. And I ordered a $3,000 signature bond through pretrial, but my conditions were to stay away from 822 Ashley Lane in Alpharetta. I was to have no further contact with Kimberly Butler, and one day anger awareness course through pretrial and a one-time escort back to that location to get any personal belongings, I believe. Anything else that I left out, Ms. Bridgewater?
To continue his AA meetings.
Oh, yes. And to continue the AA meetings, yes. And so there is an allegation there, Mr. Butler, that you made a call to Miss Butler shortly after leaving the courtroom. And that's what I need to ask Miss Butler about. Raise your right hand for me, Miss Butler. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. After court commenced for this case with Mr. Sanford Butler, and you left the Zoom call, did you receive a phone call from Mr. Butler?
Yes, ma'am, at 3:18.
Okay. And are you comfortable just summarizing what was the nature of that call?
I didn't accept the phone call, and the voicemail was just the automated jail. You know, this is a call from an inmate, and I reached out to Miss Cheney for how to proceed. Not just because I've never done this. So.
Right. And Miss Cheney is the victim witness advocate with the Solicitor General's office. Is that correct?
Yes.
Okay. And so you understood the ruling of the court. Is that correct?
Yes, ma'am.
That you were to not have any further contact with Mr. Butler, correct?
Yes.
And you did not initiate that call, correct?
No, ma'am. I haven't taken any phone calls since he's been there.
Okay. And do you want any contact with him?
No, ma'am. No, I mean, no.
Okay. All right. Deputy Falk, help me handle this. What is the state's recommendation?
Your Honor, I will say we are in the unusual position that I've had defendants contact witnesses and victims subsequent to court, but never this quickly. So the state would say that I understand that many explanations for this could be offered. However, the reality is Your Honor ordered a no further contact, and within less than an hour of ordering that no further contact to Mr. Butler while he was seated in the courtroom and could clearly hear and understand you, that order was violated. So at this point, the state would ask that this be converted to a surety bond.
Okay. All right. And Ms. Kim?
Yes,
Okay,
ma'am.
Sorry, Bartels, I'm
It's
sorry.
Mr. Bartels.
Yeah, that's my case, Your Honor. Yeah, I would just want to make a couple points, Your Honor. He is not out on bond, and I don't recall the exact language that Your Honor used, but I've heard other judges that do run this calendar say, while you're out on bond, the following conditions will apply. I believe that when this phone call was made, well, Mr. Butler advised me that he misunderstood what the contact order was. He knew that he was supposed to stay away from the location. He knew that he could not go back there except one time with a police escort. And he indicated that that's what he was calling Ms. Butler, was to arrange a time to come to get his belongings. And he did not believe that he could not make a phone call just for the purposes of trying to get his property back with the police escort. I don't know whether the order was signed at the time. I don't know whether it was filed. And, you know, if he was not out on bond and under the conditions, then my argument would be it should still be a signature bond.
Well, let me say this. In order to arrange for a police escort, you call the police. You call law enforcement. So I don't know that I buy the argument that he was calling her to arrange a time. He is to contact law enforcement and they contact her to arrange a time.
It could be that he's never had to deal with this situation.
I've never had to deal with this before, Your Honor.
Yes, sir, I would not say anything at this point. That's my advice.
Yes.
Yeah, I do have serious concerns, especially with the victim coming forward stating that she understood and didn't want any contact. And I really believe that Mr. Butler understood. I don't know, again, whether he was calling about bond, whether he was calling about picking up his belongings, or whether he was calling to, apologize. I have no knowledge of why he was calling, but to go back to his cell that quickly and call the victim, I just don't buy the argument of trying to arrange to come get his items that fast. He's not even going to be out of jail that fast, even with a signature bond. I am inclined to I have not signed the order yet. It's not been filed yet. I've not had this case either very often where anyone violates, within the hour by making a phone call to the victim, when I think I'm very clear, and it was very clear, of no further contact. Whether the ink is dried or not, or whether the clerk has stamped it or not, he was told in open court, on the record as well, what his conditions were, obviously, and to not violate them. So I'm going to change it to a $3,000 surety bond, and not a signature bond, because I just don't know that I believe that he was unsure about what to do. And the first person he calls is the victim that he knows he's not supposed to call. So I'm going to change it to a $3,000 surety bond, Ms. Bridgewater. And again, all the same conditions, continue with his AA meetings. I'm going to also order that one-day anger awareness course, a one-time police escort. The only people you should be calling, Mr. Butler, so that it's clear, when you're released, is law enforcement to arrange a time. They will call Ms. Butler to see when is a good time to go there and get your personal belongings. You better not show up there, because she will call the police. I'm instructing her to have you arrested if you show up at the home without law enforcement to get any items out of the home. And Ms. Butler will not talk to you about that. And I'm sure she's not going to violate the conditions or assist you in violating them. So again, you are not to call her. You are not to contact her in any manner. You are to stay 200 yards away. You're to not contact her by email, by any other family members, relatives, friends, employees, co-workers, or anything. No emails, no Facebook, no Instagram. So do not contact her at all. And is there anything else that I've left out?
Nothing from defense, Your Honor.
All right, thank you. All right, thank you, Ms. Butler. Good luck to you.
Thank you, ma'am.
All right, thank you.
All right. Position 3, Elvery.
Okay. This is 22 CR 0060221B. It's Travis Ellerby. You're charged with 1 count of simple battery. The offense date is July 14, 2022. Pretrial.
What we on?
3 Ellerby.
Fifth arrest after 2013 public disorderly conduct out of South Carolina. 2012 entering premises after warning conviction. 2006 shoplifting. That's it.
All right. ASG Mitchell.
Yes, Your Honor, in this case, the defendant battered Mr. Lonnie, spelled Lonnie, Perdue, spelled Perdue, who was other persons formerly living in the same household, by shoving him in the chest. Mr. Perdue stated he's known defendant for several years now and that they do not get along. He evicted the defendant from his residence on July 14th of 2022. After the eviction, the defendant showed up to Mr. Perdue's porch claiming to be there for his mail. Mr. Ellerby told Mr. Perdue told defendant to leave since there was no mail for him there. That's when the defendant pushed past him to get into the house by putting his forearm against Mr. Perdue's chest and moved him out of the way. And at that point, they got into a scuffle as Mr. Perdue kept defendant from getting inside his home. Your Honor, the state's recommending a $3,000 signature, a signature bond, no further contact with the victim, Mr. Perdue, a stay away from incident location 3258 Cascade Park Boulevard, Southwest, Atlanta, Georgia, 1 day anger awareness, and no alcohol, drugs, and weapons. We do believe signature bond is appropriate in this case, being that he lacks a violent history and his last arrest prior to this one was back in 2013. So nothing further, Your Honor.
All right, Mr. Bartels.
Yes, Your Honor. Well, thank you, Ms. Mitchell, first. I certainly would concur with the state's position on the signature bond. I am informed that Mr. Ellerby is employed full-time. He works at World Emblem. He's a quality control inspector for a clothing company. I'm told that he's been in Atlanta since 2015. He just took a little bit of time off in 2016 to care for his father after his mother passed away, but he moved back to Atlanta. So he does have a job. He does have ties to the community. And I don't believe there's any reason he would need to go back or have contact with Mr. Perdue.
He does not actually reside there, is that correct?
That's correct. He hasn't resided there in a while.
Okay, all right.
Your Honor, I would like to emphasize the stay away. Our victim advocate had an opportunity to speak with Mr. Perdue, and he stated just 3 weeks ago, the defendant was standing outside his yard watching him. So we want to make sure that he understands to stay away.
All right. I thought I saw earlier, but I don't see him now. I thought I saw Mr. Perdue on here. I still see him.
It is Lakia.
Okay.
It's still on the Zoom, Your Honor.
Okay, there it goes. Mr. Perdue, do you
Video, so I don't know.
Oh, no video.
I didn't say no video. I asked him to start his video. He has not complied. Now he's
There he is. All right. Mr. Perdue, do you wish to address the court today? Yes or no?
He's driving.
You're muted, sir.
You're still muted. Still look at your mute. I hope you're not driving since you're looking around. If you are, you need to pull over. I'm not going to talk to you till you pull over. Okay. First, you got to pull over. And then once you pull over, you can use your hand to unmute yourself. He's driving. If you don't pull over in a few seconds, or if you can't, I'm going to not allow you to testify because I don't want to hold up court waiting for you to find the spot to pull over.
I think he's saying he doesn't want to talk.
Oh, maybe he's saying he doesn't want to.
It
Okay.
looks like he was shaking his head. Okay.
I know, I
we
just
got
thought
it.
maybe he had the radio on. I don't know, and he was shaking his head to some music. Okay. All right, Mr. Perdue, we see you there. And please be careful since you are driving. I won't talk to you anyway since you're driving. All right, so I will go ahead and Mr. Bartels, you've given me your testimony, and I will go ahead and issue the signature bond, the $3,000 signature bond through pretrial.
Thank you, Judge.
There will be no further contact with Lonnie Perdue. Stay away from 3258 Cascade Park Boulevard. I'm going to order the 1-day anger management or anger awareness course through pretrial, and no drugs, alcohol, or weapons while on bond. So is that clear, Mr. Ellerby? You are not to return to that location, not to get mail. You do a change of address at the post office, and your mail will be forwarded to you.
I did that, Judge.
Okay, yeah, you can't go back there, sir.
I didn't change it all.
Okay, all right.
All right, and no further contact with Mr. Perdue. Do not call him, do not email him, do not contact him. Okay, all right, thank you.
I don't know his name.
Okay, good.
Okay, all right, thank you, Your Honor.
Thank you, uh-huh.
Position 2, Cantrell.
Thank you.
All right. So this is position 5, correct?
I think this is number 2, Mr. Cantrell.
Number 2.
Oh, 2, Cantrell, I'm sorry. This is 22 CR 006010C, Rashad Cantrell. You're charged with 1 count of criminal trespass, the 2nd count of possession and use of drug-related objects. The offense date 9/6/2022. Pre-trial?
13 total. Last arrest was on the 1st of this month for shoplifting. November 2021, shoplifting, possession of drug-related objects, arrest. 2018 FTA that was dismissed. 2018 probation for simple battery. 2017 probation, simple battery. 2017 FTA not prosecuted. He was convicted in 2017 for 3 counts of simple assault. 2013 FTA, simple battery, given false name, dismissed. 2013 simple battery conviction. 2012, same thing. That's it.
All right, ASG Duncan?
Yes, Your Honor, this incident occurred at the Family Dollar located at 226 Ralph David Abernathy Boulevard, Southwest. Officers responded to the scene when the store clerk informed officers that a known trespasser had entered the property. Officers waited in the area and they witnessed the defendant in this case return to the store. The officer in this case was familiar with the defendant because he had personally warned and responded to the same location about this defendant in the past. He had previously arrested and trespassed this defendant for shoplifting, as pretrial had stated, in addition to trespassing this defendant on another instance in September of 2021. Search incident to arrest. Officers discovered a glass pipe with black residue inside that is commonly identified as an object used for smoking crack cocaine. The state in this case has a concern about the risk of reoffense given the facts stated. The officers indicated that he has not complied with orders to stay away from this location on several occasions. We also have a concern that this defendant is a flight risk. Of his 12 cycles going back the last 10 years, He has multiple FTAs, at least four arrests for FTAs. Well, 5 that I can count, in addition to several violent convictions over the past 10 years. We have a concern that he will not respond to the legal process, given that there are also probation violations indicated in his record. Given that, Your Honor, there is a $3,000 preset bond in this case. That's $1,500 per charge. The state is going to be requesting that that bond remain as such, and the defendant stay away from that Family Dollar at the address previously listed on the record. We are asking for no alcohol, drugs, and weapons, and no further violations of Georgia law, given that this defendant is a repeat offender at the location and was witnessed by an officer who was familiar going back into that store. Nothing further from the state.
Mr. Patel?
Yes, Your Honor. Mr. Cantrell is 29. I have talked to him about his case. He does have ties to the community. He's got extended family, including his parents who live in the Atlanta area. He also advises me that he works sometimes part-time, sometimes on a full-time basis, cutting grass and doing small repair jobs in various neighborhoods. And I'm aware of his history as mentioned by pretrial, but it does appear that a lot of his arrests are mainly for offenses like this. It looks like the failures to appear have not been prosecuted. And just more than anything else, just based on, what the charges are, he does want to ask the court to consider a signature bond. I did advise him of what the criteria for that are. But if the court is not inclined to do that, we would ask the court to consider reducing the total bond to $1,500. That would be a $750 good bond on each charge. And that's it.
All right. I will deny that request. I'm going to leave the bond the same at $3,000 surety bond, $1,500 on each charge. And I'm going to make sure, Mr. Cantrell, if you do make bond, you understand that you're to stay away from the Family Dollar at 2966 Ralph David Abernathy Drive, Southwest. You are to, again, have no drugs, alcohol, or weapons while you're on bond, okay? So stay away from that Family Dollar if you get out on bond.
And I just want to correct, Your Honor, for the record, I don't know if it's another Family Dollar, but it's 266.
Oh, 266.
I'm sorry, 226. My eyes are playing.
That's okay. 2266, right.
Yeah.
There could be, as long as Cascade is, but I'm not sure. But make sure it's the 2266. You've been warned not to go there before, okay? All right, that will conclude this case.
Thank you.
Position 5, Harris.
All right,
I think Mr. Harris is the only case we've got left.
it is.
Okay.
Do we still need to go into a breakout? Or since the courtroom is clear?
Well, if the courtroom is clear, I'm okay with proceeding as we are now.
Okay.
Yeah.
All right, this is.
Sorry, I apologize for interrupting. Just out of an abundance of caution, we're still recording live on YouTube. So I'm not sure if that would still warrant a breakout or if we're all comfortable even understanding that.
Mr. Bartels?
Well, yeah, I appreciate that, Ms. Falk. Yeah, on second thought, if we could go into a breakout room, that would probably be out of an abundance of caution.
Okay, and pre-trial, yeah, I won't need him. We'll let the state.
I think Ms. Kim will want to join us.
Okay. All right, Ms. Let's put us in a breakout, please. All right, this is case number 22 CR 0060114G. Tevin Harris, you charge at 1 count of criminal trespass with the offense date of 9/6/2022. Mr. Harris, we've discussed your case in the breakout with your attorney, and we're going to continue the bond at the $500 surety bond as is currently set. We're going to reset your case to the calendar on 9/15, or depending on the outcome of that calendar, then you will come back to the SAP calendar on 9/20. Okay, so we're resetting your case today, all right?
All right, and one of us from the Public Defender's Office will be visiting you, Mr. Harris, okay?
So remember, if you were to get out on bond, that you are to stay away from the Emory Johns Creek location at 6325 Hospital Parkway, only for receiving treatment, but you should not go there for any other reasons, okay? Okay, all right, thank you.
All right, Judge, we're completing in courtroom 2.
All right, thank you.
Thank you.
Okay, so are we ready to go over the calendar?
Yes, ma'am.
Okay, once again, the reset date for the SAP calendar is going to be September the 20th. Position number 1 is now going to the SAP calendar with a $3,000 good bond. Position 2 is going to the SAP calendar with a $3,000 total good bond. Position 3, reset further notice with a $3,000 SOB through pretrial. Position 4 is going to the SAP calendar with a $5,000 good bond. Position 5 is going to the MH calendar on the 15th with a $500 good bond. Position 6 is going to the SAP calendar with a $4,000 total split bond. Position 7 is going to the SAP calendar with a $2,000 good bond. Position 8, SAP calendar with a $10,000 total good bond. Position 9 is going to the SAP calendar with a $10,000 total good bond. Position 10, reset further notice with a $2,000 SOB through pretrial. Position 11 is going to the SAP calendar with a $2,000 good bond. Position 12, SAP calendar with a $2,500 good bond. Position 13, SAP calendar with a $4,000 total good bond. And position 14 is being reset further notice with a $4,000 total SOB through pretrial. Are there any questions, comments, or otherwise?
I did have just to clarify on number 6. I got the MH reset date on the 15th, but
Number
it is
6?
Not number.
sorry, number 5.
Yeah, 5.
Number 5, yes, sir.
Okay, so that should have a 9/15 for MH court and also SAP on the 20th.
Right, because we don't know.
Okay, so I'll set them on both calendars.
Okay, yes, ma'am. I
Off
just
on the 15th, and we'll take it off for the 20th.
Right.
Okay,
yes, ma'am.
all right.
That's
Are
it.
there any others?
Nope, that'll do it.
All right, then that's it. You all have a good one. Okay.
Well, thank you. Good afternoon, everybody.
You too. Bye-bye.
Bye.